Good morning, everyone. It is your friend Rick. It is October the 26th, 2017. The day is Thursday. If you need to contact me because you wish to make a donation to receive my paperwork, my email is rick, R-I-C-K, 0327 at me.com. All right. What you're seeing on the screen right here is a notice of demand, change of venue, court of record. All right. Many of you are dealing with a child support agency being a petitioner, which under common law, which our country is a common law country, and in a court of record, a uh, a, a corporation or a non-human cannot show an injury in fact. Okay, that's why they're in statutory courts or they're in these Nias Prius courts, which means before unless. So you're in a court that's operating until you object. So, 99% of us do not know what that means. All right. And the lawyers, most of them don't know what it means because they go to law school and all they're taught is procedures. Okay, they don't even, from what I understand, they don't even talk about the Constitution that much. I mean, they might have like a portion of a semester geared towards it. You would think that a lawyer would be focusing on the Constitution, but the lawyers don't like the Constitution. The judges don't like the Constitution. You bring up the Constitution, they roll their eyes at you. I mean, that's what used to happen to me all the time. And to me, uh, when I was a police officer, I used to, focus on the Constitution. I was lucky enough that when I was in the police academy, uh, my law instructors, one was a lawyer and he was a sergeant, and the other was a sergeant who was very active in drug interdiction on the George Washington Bridge. So, you learn that you got to learn the Constitution, and you learn what lawyers are going to ask you when you're on the stand. You're supposed to think all the way down that road when you make an arrest. And if you see that you cannot answer a question lawfully, you're making an unlawful arrest, and it's not worth it. At least that's what I found. And I made many, many arrests, and I had to testify many, many times. And I only had one case overturned on appeal. So I did pretty good. Anyway, so what we want to do is in a court of record, the child support agency cannot be a petitioner or a claimant. And most of you are dealing with these child support agencies as the petitioner because the baby mother, or whatever you want to label her, is signing over her support rights to them. Okay, which basically makes them a third party. So it's supposed to be, she's supposed to be, or he's supposed to be bringing to the court or to the clerk's office when they file a petition. They're supposed to be bringing some type of evidence of an injury in fact. Okay, giving the clerk probable cause to draw up the petition and start the whole process. Except in child support, they don't do any of these things. So what we're trying to do is we're gonna bring all of these things to light, okay, and make it harder for them. All right. So you guys saw I did a video a couple of weeks ago, 2 or 3 weeks ago, about sending in special appearance. So as soon as you guys receive something in the mail that you're supposed to go to court, I have you send out the special appearance affidavit, okay? And in the special appearance affidavit, we're demanding to see evidence of an injury in fact, okay? And what we're really doing is we're setting them up for a default, because most of the time the clerk, they ignore these things. And I'll give you an example. Okay. This is a response to one of my subscribers. He got, you see here on October 23rd. All right. And you see it's a response to special appearance. Let me see if I can make this bigger. Okay. The court is in receipt of your notice for special appearance. So, okay, right then and there, we're seeing that my paperwork is getting a response. That's what we want. Remember, all I'm doing is putting you guys in a position to win. I cannot make any guarantees, but being in a position to win is a pretty good place to be. Okay, and if you keep pushing like I did, you can triumph. Okay, all for a small donation. You get a whole bunch of paperwork, and this is one of them. Okay, so the matter that is on our court docket is for a civil support petition for child support. Now watch this. Filed by the Division of Child Support Enforcement at the request of his baby mama. Or no, excuse me, that's his ex-wife. Excuse me. Attached is the petition that was filed with the court. Now, we demanded to see the evidence. So right then and there, we have a default. Okay, FC. All right, you're watching this. What you're going to do is you're going to file the, I already sent it to you through the email. What I had him file was, hold on a second here. Okay, this is it here. All right, now this is in my paperwork. Remember I told you guys, I have so many different remedies, it'll make your head spin because I'm constantly adding things. This thing here, I just added this just now in response to this. Okay, because my mind is always spinning to help you guys win. That's how I started out with just 6 affidavits, and I'm well over 40 affidavits. Okay, so that's what we're doing, and I seem to be on the right track. So anyway, so we received that response, okay? The Division of Child, how can it, at the request of? Now, the Division of Child Support Enforcement is the petitioner for his ex-wife. So how can the Division of Child Support Enforcement be an injured party? Okay, remember, a lot of you are catching on now, and I'm proud of you guys. A lot of you. You guys go into court now, and you're saying to the, to these phonies, these fake judges, where's the injury in fact? And a lot of you guys are doing good, okay? And, they're still up to their old tricks, one guy he challenged the commissioner. The commissioner lied, said that the commissioner is a judicial officer. Then the commissioner said that he or she is not going to provide his oath of office at his request. They cannot do that, okay? This is, in my journey trying to help you guys, is we're always learning, okay? I'm by no means an expert. I'm learning with you guys. I just happen to have a leg up on a lot of you because I have a 4 or 5 year head start on you guys, all right? And I showed you guys in my old videos, I got boxes of paperwork, and I got some boxes that's still in storage. So I've done a lot of trial and error, okay? A lot. But, it's paying off because I'm pretty good at this stuff now. Anyway, oh shit, what was I just saying? Anyway, I'll try and remember. The Division of Child, anyway, there's no proof of an injury in fact. Oh, I was saying the commissioner was not, I'm not going to give you my oath of office. That's a bunch of BS. So what you should do is file an objection and then file, I think this is in California. In California, you got these crazy laws with the writ of quo warranto. But what you can do is you could file an objection. Anytime these people object to you in court, they refuse in court, make a notation in your mind. As soon as you can, write it down and file an objection. You can handwrite it, okay? You could make up something like this, notice to the court, you write objection, and then you write down here what you're going to do. Objection. I demanded to see the oath of office of Commissioner so-and-so. Objection. It is my understanding that commissioners are non-judicial officers, court employees, and Commissioner so-and-so, on the record, for the record, made the claim that he or she is a judicial officer, and I know this to be untrue, and I believe this is misinformation, and this, this is what I'm saying now. I'm not telling you to write this down, but you can write it. That is the definition of fraud in the court. Okay? Whenever somebody's in the court, a lawyer, these commissioners, a judge, when they are giving you misinformation while as a officer of the court or the presiding officer of some administrative, they are committing fraud on the court. They're supposed to be telling you the truth. All right, you want to get one of these people to get really angry at you and really go crazy? Ask them to raise their right hand and swear under oath of perjury on the record. Ain't happening. I had a phone hearing last year with my pension system, and it was me against the pension attorney, and I had this retired judge, and this is a phone hearing, by the way, and I had the retired judge who was the hearing officer, and he would not have I demanded that the pension lawyer be sworn on I had to swear on the phone, an oath on the perjury. He wouldn't let him do that. He goes, well, he doesn't have to, he's a lawyer. I go, yes, he does. I go, he's a witness to this case. He's the one that caused all this injury to me. Well, yeah, and I got so mad. I said, listen, this is a bunch of bullshit. All right, you guys are not even following the law, not even close to the law, and now you're telling me he doesn't have to be sworn in when I know he has to be, when he's the only witness for the pension system, and I hung up the phone on him. It's a complete kangaroo court. Okay, but I got it on record. A lot of these things, you got to get this stuff on record. All right. So again, file objection. The commissioner offered misinformation. That is the definition of fraud in the court. Unless whoever you're filing this to the court, the objection, and unless otherwise can be proven. Where's the proof that a commissioner? If the commissioner is a judicial officer, then why is the commissioner not called the judge? You know what I'm saying? So they're not a judicial officer. They're quasi-judicial. That's it. It's part of the scam. They work for the executive agency. They're not, just because they work for the courts doesn't mean they're a judicial officer. All right? Then what would you need judges for then? Okay? Why are judges wearing black robes and they're not wearing black robes? You get it? All right. So anyway, my subscriber, I just showed you this. Now, what I sent to him is, and you guys as well, you're going to send this in, notice to the court, demand for dismissal, lack of jurisdiction, default, because they're defaulting because you sent in the special appearance demanding to see the evidence of an injury in fact before you show up. And guess what we got? We got this response, all right? And he just emailed me the other information, and there's nothing more than the petition, okay? There's nothing more than the petition. So the clerk is claiming that's the evidence, the petition, all right? The petition is not proof of an injury in fact, so they defaulted. So he's going to send this in, right? Injury in fact, 28 U.S.C. section 2072 is such rule should not abridge, enlarge, or modify any substantive right. All right. So these rules, any court rules, this is also good, by the way, for guys and girls trying to file paperwork with the clerk's office. This is another law in your favor. So like these court rules, these bullshit, because we are getting close right now, guys. A lot of you are getting very close with my writ of mandamuses and my writ of habeas corpus. These people are getting really vicious now. All right. sending back paperwork with no reasons, refusing to accept the paperwork. All right? Because the closer we get to a remedy, the harder it is for us to get the paperwork submitted. All right? I'm going to do a video on that. I tightened up the paperwork yesterday. I don't have time right now because I got to be somewhere in a little while. But with the clerk is nothing more than a ministerial employee. They're not a tribunal employee. In other words, they have absolutely no business reading and interpreting your paperwork. All right? You be writing in Russian if you want. The court must go get a Russian interpreter to interpret your paperwork. You understand? So just because you do not speak English doesn't mean you have to write in English. But the way they look at it is, well, you got to do everything the way we say it, these court rules. It's not formatted the right way. You know, all this baloney. Like, look, see, you know what I do? I just keep it simple. Here's the court, the county, the state. You got the claimant, the petitioner, that's it. That should be accepted in any court in the United States. You understand? Some courts do things different. They want it up here, your name, all that stuff. I just keep it simple. All right? That's it. This should be accepted by every clerk in every clerk's office in the United States. All right? And we're having a hard time. All right? So, again, you're going to send out the special appearance. Hopefully, you're going to get a response. Now, let's say you're 10 days out, right? And you haven't received a response. Because remember, we're going to send this out as soon as we can. All right? Now, if you don't receive a response before 10 days, all right, let's say you've given them, let's say they've had your paperwork for a good 2 weeks now, and you haven't received that, you still filed this anyway, because we're going to get their attention. All right? Notice for dismissal, right? Default for failure to introduce evidence of an injury in fact. All right? And then the bottom, I have a section for evidence. Right? Anytime you write Exhibit 1 on the bottom of the evidence, all right, and you have to submit this with your paperwork. You also have to submit the affidavit of service. All right? So let's say you're submitting this, right? Now you're gonna, at the back you're gonna staple Exhibit 1 is the special appearance. That's Exhibit 1 because you're showing evidence that you notified the clerk's office of a special appearance demanding an injury in fact. Okay? Then Exhibit 2 is hopefully it's the response to the special appearance. Okay? And any other evidence you think may help you. All right? Submitting evidence is very, very important because we're submitting evidence, they aren't. So this helps our case. Okay? And also, you're going to submit. Well, actually, what I'm going to tell you guys to do from now on is when you submit the special appearance paperwork, I want you to submit the notice of demand, change of venue, court of record. Okay? A court of record is a tribunal having attributes and exercising functions independently of the person of the magistrate. You know what that means? That means the magistrate is nothing more. The magistrate is a judge, by the way. And under common law, they weren't called judges, they were called magistrates. All right? And it's independent, meaning it's a jury trial. Remember, we always want a jury trial. A court of record is a jury trial. All right? And the jury is what makes a decision. Real quickly, I told you guys a story in one of my videos, I think it was in my car, about a friend of mine, Steve. And he was a great guy. He started out as a police officer. He worked up in the Bronx, and he didn't like their stop and frisk policy. All right, the neighborhood we grew up with a bunch of different. We had Puerto Rican friends. We had some black people around. We went to high school with black people, but we don't play that stuff where I grew up, the racism stuff. And the sergeant, who was Hispanic, by the way, was having them jump out of the car and pat frisking anybody walking down the street. Now, this was in the South Bronx, so walking down the street in the South Bronx, you're either black or Hispanic, okay? So they were just grabbing them and pat frisking them. Now, if you go pat frisking everybody for any reason, you got to come up with a weapon. You know, I used to laugh at some guys, you know, because everybody knows I'm a retired cop. I'm like, I made all these gun arrests. I'm like, yeah, okay. If you pat frisk 100 people, you know, in a bad neighborhood, you're going to come up with a gun sooner or later. Try and get a gun collar actually following the law. See, that's what I used to do. You got to be around the truth. Okay? So what they would do is they pat frisk 100 guys, find the gun, and then make up some bullshit story after. He was walking, and every 5 steps he was readjusting his waistband, or, you know, I noticed a bulge, and, you know, it's all baloney. Meanwhile, the other 99 people were just being harassed for no reason. So anyway, Steve left. He didn't like it. Butted head with his bosses. They were breaking his balls. He left. He went to the fire department. Fire department wasn't for him. He was a family guy. So he left there and went to the New York City Sanitation Department. And 3 years ago, unfortunately, he got in a tragic accident. He was working with a street sweeper doing the maintenance, and some fucking sanitation guy hit from behind. This was in the garage, by the way, and Steve got crushed and killed. Anyway, it's in the New York Daily News yesterday. His family was awarded $41.5 million in a wrongful death claim. So I just wanted to, you know, if anybody wants to go and Google it, that's my friend I was talking to you guys about. And, you know, it's proof that a lot of my stories aren't bullshit to you guys. You know, I like to talk a lot with my anecdotal stories. Steve Frosch, Frosch. All right, and getting back down, we're going to get back to the court of record. We're a common law country. A court of record is, now a common response you might get is, well, yeah, we're recording them. We have audio recording. No, I don't mean that kind of recording. A court of record is where everything is for perpetual memory and every decision is unappealable. Do you know that a jury trial in a court of record is technically unappealable? Okay, I mean, you can appeal, like, if the judge gave, you know, some of these judges are out of control. See, judges have a hard time not being in control. That's why you don't see, actually, it's very difficult to find a common law jury, trial by jury, because it's all statutory courts. All right, but we're going to get this on the record. So we're going to change the venue to a court of record. In a court of record, a child support agency cannot be the claimant or petitioner. We also remember, hold on a second here. Remember, Lou Jan, Secretary of the Interior versus Defenders of Wildlife et al., right, is a 3-pronged approach. First, the plaintiff must have suffered an injury in fact, okay? Actual or imminent, not conjectural, hypothetical. What's a hypothetical? Well, he didn't support his children, so the mother had to go on welfare. Well, that's hypothetical. Okay? There's no solid proof, because there's plenty of women that go on welfare and still get paid child support. Many guys pay by cash or by check, and the women still go on welfare. Okay? Second, that there must be a causal connection between the injury and the conduct complained of. All right? It has to be traceable. So it has to be proof that you caused the injury. And lastly, wait, I'm sorry, guys. I'll find it eventually. I think I didn't put all of it in there. But anyway, third, it must be likely, as opposed to merely speculative, that the injury will be redressed by a favorable decision, meaning that there's likelihood that it's going to be successful. Well, it's not going to be successful if you don't have evidence of an injury in fact, and you cannot prove that you caused the injury in fact. All right, many of these cases will never see a jury, and even if they did, the jury wouldn't find for them. But remember, they don't give you the opportunity for a trial by jury because it's all fraud. Okay, but this is a United States Supreme Court decision. I try to use Supreme Court decisions as much as I can. Okay, and when I found this one, I was jumping for joy. It's a great one. Okay, so again, this video is, you know, a bunch of things, but it's in response to your demand for under special appearance. Okay, and this is how you're going to respond. Okay, you're going to respond with notice of court, demand for dismissal, and it's under the title demand for dismissal, failure to state a claim. If a petitioner does not provide proof of an injury in fact, that petitioner lacks standing and to prosecute, and the court lacks jurisdiction to prosecute. It's that simple. Very simple stuff. All right, child support cases, they never even talk about that. A few of you guys out there have done this, and they've played stupid. Oh, I never heard of that before. I never heard of it. You never heard of an injury in fact? What, are you kidding me? What do you have? They have lawyers on the doing commercials all morning about injuries. It's the same injury. An injury in fact is an injury from a car accident. All right, you have these ambulance chaser lawyers. It's the same thing. Okay, but your injury doesn't have to be physical all the time. It could be economic. It could be mental. Okay, so it just has to be something. Well, mental. Well, you're going to see a psychiatrist. You can have your wife, your girlfriend testify that you're up all night. Or you're taking medication for insomnia. Economic. You know, like myself, I can prove that my house, I had to sell it because it went into foreclosure because they were stealing my money and I couldn't pay my mortgage. You understand? These are all things that can be proven. All right, so I'm going to shut this video down. I hope you guys learned a bunch. Again, if you need to reach out to me to receive my paperwork, it is Rick0327, and I'm going to just give you a glimpse of one of my folders. These are affidavits for support. Okay. This is just one folder. Well, there's a lot of the affidavits. So, you know, it's different things. So we're dealing with what I was just showing you. So I'm like, oh, let me look. Okay, demand right here, failure to state a claim. That's just one. Demand proof of an undertaking. Demand to dismiss, quorum non judice. Demand to vacate, quorum non judice. Demand to vacate, default judgment. That could be used for that also. Okay, all of these different things that I have for you guys. All right, just for a fairly cheap donation. All right, guys, enjoy the rest of your day.